Sonny is a partner in the law firm of Heidemann, McKay, Hughley, and Olsen. We have offices here in Spanish Fork. Sonny graduated from the University of Iowa Law School. Sonny was co-counsel and spokesman for several families of the Crandall Canyon mine disaster back in 2007. He enjoys complex litigation of all sorts. Recently, the the Legal Media Group, which is a global organization, listed Sonny as one of only 36 legal litigation stars in the state of Utah. He's a nationally syndicated radio talk show host on XM Sirius 143. He and his wife, Bandy, been married over 10 years now. They have 4 beautiful children, and they live in Salem. So, Sonny Olsen.
My dad died at 43. I was 13, had an older brother and a younger sister at home. Dad left my mom a pension, $1,800 a month, $750,000 in cash, and a life insurance policy, no estate planning. It all came into my mom tax-free. About a year later, my uncle devised a scheme to make us all rich with oil. She gave $320,000 to him, never saw a dime of that. Then my mom was used to living on $85,000 a year, supporting a family, and so that was gone in 4 or 5 years. And sadly, my mother was in a situation where she needed health insurance, and she remarried, and then she remarried again, and then she remarried a third time. My mother and my father were married for 25 years, and they were, I guess, as happy as anybody else. She got remarried, and she'll tell you, and she's told some of my clients, I had to remarry because I needed health insurance. It wasn't really so much for companionship, it was out of need. So I went to law school. I chose the University of Iowa. It's a top 20 law school, and I went there because they had an opportunity to clerk at the Iowa Nonprofit Resource Center under President Boyd, Sandy Boyd, and I learned how to start estate planning there. And I promised myself that I would never let money decide how I represented a client, and I would always make sure that no matter what happened, my client would never be in the same position that my mother was in. And what happened to my grandfather? My grandfather was a coal miner. He worked 36 years in the coal mine, multiple injuries, amassed a farm, really had quite a bit of money. He lived a nice lifestyle and was really going to pass a nice legacy on to me and my family. Well, he passed, no estate planning, passed everything to Grandma. Grandma got everything. She went downhill fast. She passed away, and it was just a free-for-all, no planning. Before she passed away, several of my uncles, not my favorites, really convinced her to deed them over the farm and the property in advance of her dying. That triggered a huge capital gain tax issue and a huge tax bill when my grandma died. The IRS came in. Before all was said and done, my mom didn't get anything. She got nothing of over $1 million estate, okay? I will not let that happen to my clients, and anybody that does any kind of competent estate planning doesn't just give you a document, okay? They don't just give you a document and say, here's your estate plan, go do something with it. That's malpractice in my opinion. It's not legal malpractice. In my opinion, it's malpractice. So for purposes of this presentation, I want you to leave and know that if you're going to go hire someone to do your estate planning, you better hold them to a high level. They should not produce you a set of documents. They must, after they give you the set of documents, teach you how to fund your trust and how to use your trust and how to use your LLCs so that you can save tax money and so that you can be protected like my mom should have been protected and protected like my grandma should have been protected, okay? Those are things that are essential, and that comes from experience and just a very practical way of going about doing estate planning. I hope that makes sense to you. I noticed there are some business people in the room. Theory and books, that's great, but practical hands-on planning is what you need, even if you need just a basic estate plan. For instance, I'm going to tell you how I did my estate. I have a lot of life insurance, over $2 million of life insurance. I don't just plan for that all to go to my wife. My wife and I sat down, we drafted a trust, and I said, babe, how much money do you think you're going to need? Well, I'll need this much money. Where's our mortgage payment at? How much are you going to have to pay the mortgage off? My trust says, pay this much off on the mortgage. Put this much money for each one of my sons to go on an LDS mission. Put this much money aside to pay for their graduate work. So it's all taken care of before I'm even gone. That's an hour-long discussion with your attorney. But you know what? Most attorneys don't do that because they're book smart, but they're not applying what you need on a street level. if that makes sense. Flip your first presentation page. Go to number 2. It says estate planning. Who needs it and when should it be done? Well, you know my mom needed it. You know my grandpa needed it. So who needs it? If you have children that are minors, you need an estate plan. You need a family living trust with a provision in it that says, and you can write on this, take it home, make some notes on it. If you got children, they're minors, you need an estate plan. It needs a provision in it that says, if I die or I'm incapacitated, this is what I want to happen to my children. If my wife and I die or we're incapacitated, car wreck, disaster, whatever, this is what I want to happen with my children. I want my cousin Susie to raise these babies because I know she knows what my values are and I want her to raise my kids like I'm seeing her raise her kids. If you don't have something like that, guess what happens? Parents patriae, it's Latin for the state as the superparent. Superparent comes in, the judge, and he or she will decide where your children go. Okay? It's that simple. If you don't do something like this, then you're putting yourself in that situation. I can tell you I practiced law for 7 years. A lot of litigation. I've seen almost everything in just 7 years. And I've seen several cases just like that. You don't want your family members fighting over who's going to take care of your babies. When should your estate planning be done? Well, I'm going to step back. If you have life insurance, like me, be smart. If you have life insurance, dump your life insurance into a trust and then have your trust irrevocably dictate where your money's going to be spent. I don't want to just give my wife $2 million. She's grieving. She's unsophisticated. You know, she's raising my baby. She's great at being a mom, but she's not great at investing money. I tell my trust, the trustee of my trust, I say, go see this person. He will invest the money wisely, and here's exactly how much. If you have life insurance, you need a trust. You need some kind of estate planning. If you're not married, you probably don't. If I could pare this down and you're not married, you probably don't need an estate plan. But if you're married and you have life insurance, or if you're married and you have kids, you got to have some kind of estate planning. I'll tell you right off the top, most attorneys in Utah County will do a family living trust for $1,750 or less and everything that you need for a basic estate plan. Okay, so that's kind of the cost that you'll experience for a basic estate plan. When should your estate planning be done? I love this picture. I don't even know where I got it. I've had it for a while, but I love that. You know, you have the fish hooked. I forgot to get my will done, or I forgot to write my will. Everybody says that. Hey, I'm not here to sell you anything. I make more money as a law firm and as an attorney when people have to probate their estate. Okay? Do you know what probate means? Probate's a dirty word for the court will decide, or the judge will decide who gets what in what amounts. And it's usually following a state statute. If you die without a will or a trust or some kind of an estate plan, or if you die and your attorney committed malpractice and didn't do it right, you have to probate that estate. Or if there's property that didn't get transferred into your trust, then you have to probate, go to the court and say, Judge, who owns this property? Help me change the title. So probate's a process. It's expensive. $4,000 or $5,000 retainers are common for an attorney to probate an estate. Okay? So you don't want to be in that position. You don't want to be in the position of having to change title to your property. And I'll give you an example. And it goes to this point, when should it be done? Now. It has to be done now. You can't wait. If I have a piece of property that's just in my name, it's not in my wife's name, theoretically. If I have a piece of property, maybe it's some cabin property somewhere, I pass on, she's alive. She can't go transfer that property into her name as the surviving spouse. She's not on the deed, and I'm gone. I can't do it, so she has to go to the court. The court has to say, Bandy Olsen, you're now the lawful owner as the heir, the surviving spouse of Sonny Olsen. Then she's got to go pay a title company to prepare the deed and then go record the deed. $1,500, $2,000, just like that. That's an easy example. Think about what if you had car titles that were just in your name. So you think about probate really as a titling issue, okay? And what if you pass on, you and your wife pass on, and you've got multiple children, and you'd promised your kids, look, you help me on the farm, I'm going to take care of you. Well, you died suddenly without taking care of that person. Guess what? The court doesn't care. The court has to follow the laws as they're enacted in the state of Utah. And the law is, if you die, everything goes to your wife, right? If she's gone as well, everything goes to your kids in equal shares. So you lose that opportunity to take care of that child as if you had, like you told them that you would. And that presents a problem because guess what that son or daughter does? They look at the others and they say, no, 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 I'm not taking equal shares. I worked for 25 years on this farm, blood, sweat, and tears. That's not right. It creates interfamily conflict. And you know what? Judges can be sensitive to those arguments. And then you got litigation, and you got a family that's blowing up, spending money with attorneys, tens of thousands of dollars with attorneys. So don't do that. Get your plan done now. Make it a goal to get it done in the next 2 months. It's not that difficult. It's not that expensive. And I put this in the very beginning. You don't want your attorneys to win, okay? They win either way. You don't write your plan, you got to pay under probate. You want to write your plan and take care of things, you pay them. Just get it done sooner than later. I like this. The first thing we need to do is kill all the lawyers. William Shakespeare. I got to tell you, the first 2 attorneys I hired, I was a businessman in technology. I hired a couple of hotshot patent attorneys. And one of them I liked and one I didn't. I threw the one that I didn't like out the door. He was cocky and arrogant and just a jerk and didn't really care about my company and the issue that I had. And I thought, I'm going to go to law school because I can compete in that arena. So I sold my business and went to law school. I can, find somebody that really gets to know you as a person and that knows your family and the way you think. Because you don't want to read that trust document. It's like 28 pages long. It's gobbledygook. Find an attorney that cares about you as an individual, cares about your family, and that can learn to think like you do, and you will have a good estate plan. I guarantee you that, okay? Deterrence for estate planning. Let's think about this. I already talked about costs. Why wouldn't you get an estate plan? It's $1,750. That's a lot of money. It's around Christmas time, right? I'm here to tell you that it would be a wise investment for you at any point to leverage debt if you don't have the cash to free it up. Don't let that be a deterrent. Leverage debt. Use a credit card. Work out a payment plan with your attorney, okay? Failure to see immediate need or advantage. That's what stops most people. I'm going to last forever, Nothing's going to happen to me. Third, emotional impact of confronting death. And this is more on a psychological level. Do we have any shrinks in the room? Okay. The emotional impact of confronting death. This is actually very real for a lot of older folks. They just don't want to deal with it. They just don't even want to think about it. You might have family members. The reason I bring this up, you might have family members that are holding off, moms, dads, aunts, uncles, for that very reason. Don't let that be a reason. Because I'm not going to talk about taxes here today, okay? But those folks, that as you get older in life, you have significant capital gains issues. And you want to do your estate plan so that they don't pass on with big capital gains issue and then the IRS coming in and saying, hey, mom and dad bought that piece of property for $100,000. It's worth $2 million now when they died. You owe us tax on $1.9 million. You take care of your planning now. You convince mom and dad to do it now so that you're not left holding that great big tax bill because they're going to be gone. And you're going to have to fire or sell their estate in order to pay that tax bill. A lot of people don't do it because of lack of knowledge about tools for estate planning. I'm going to just make this simple for you, okay? If you've got less than $1 million in assets, net worth, you probably just need a family living revocable trust. That's the only thing you need. And you need your powers of attorney that go underneath it to make your life easier, avoid problems, solve issues. But you need a family trust that's freely revocable, less than $1 million. Why less than $1 million? Because the estate tax threshold will be $1 million, in my opinion, in 2013. And you can exempt everything under $1 million, so nobody's going to pay any estate tax. And you can use that family trust to get your stuff everywhere you want it to be. Solve problems, avoid fights, okay? So just write that down. If you have folks that have a more significant estate, maybe it's $2 million, $3 million in the totality between the two of them, you might need something like an irrevocable trust. Or you might need a charitable remainder trust. All right? We're going to get to those things a little bit later on. So let's go to my grandpa's example and my dad's example. Flip along to what happens if you don't have an estate plan. You ever heard of the terms intestacy laws? You've probably heard of the terms, right? Intestacy laws. Intestacy laws are a set of laws written by your legislator. They're based on a uniform set of laws. Every state has them. Intestacy means you die without an estate plan, here's what happens. And it says this: if you're married and all of the children you have are children of your marriage, everything goes to your surviving spouse. If she's gone or he's gone, then everything goes to your kid in equal shares. If one of your kids predecease you, then that kid's share, the dead son or daughter share, goes to their kids or your grandkids. What happens if you've got a blended marriage? You're married, you bring 3 kids to the marriage, all right? Intestacy says, if you die with kids born not of the marriage, then the first $75,000 of your estate goes to your spouse. Then every dollar thereafter is to be split with the surviving spouse and the children equally. So that means if you have stepchildren, the first $75,000 goes to your surviving spouse, and then the stepchildren get every dollar, 1/2 of every dollar thereafter. Most people don't know that. Okay? And so you won't be passing your entire estate on to your spouse like you think you will. Right? Probate, we talked a little bit about that. The high cost of probate is you'll spend $4,000 to $25,000, $30,000 to probate an estate. And it usually involves litigation, which is family members hiring attorneys. And so you've got multiple parties spending tens of thousands of dollars. Not efficient way to handle your estate. Okay? Higher taxes and estate settlement costs. I want you to write this down because I've seen this happen a lot in Spanish Fork, and I don't want this happening anymore if I can do anything about it. Mom and dad, somebody tells mom and dad, hey, you can qualify for Medicaid if you don't have any assets, so transfer your farm over to us, transfer your house over to us, put it in my name, I'll let you live there and you can just stay there until you pass on. Let's just do our estate planning that way. Don't go pay your attorney. Well, that creates several problems. First, it creates a great big capital gains issue. Now, capital gain is a simple concept. You buy a piece of land for $1,000, you sell it for $10,000. That was a nice investment, right? You made $9,000. Well, that gets taxed anywhere from 18 to 23%. That's a gain. So if you transfer your property to your kids, you should file a gift tax return, right? You made a gift, you transferred a gift, and you need to report that there was a gain. If you don't do that, guess what happens? Nobody's doing it. Most people are not doing it because they're not doing it to make a gift. They're doing it for estate tax purposes. Well, the IRS is out there perusing, and they have automated software now, perusing the county recorder's records, and they're seeing when transfers happen, and they have a way of knowing. They swoop in with penalties and interest going back to the date that it was transferred. And if it's 20 years ago, you compound interest and the gain, and man, it's a huge tax bill. In many cases, I had a case come in 2 weeks ago, it was the entire value of the piece of property, the tax and the penalty of what the property was. The IRS doesn't care. They took the property. Okay? So don't let that happen. Again, just go back. Don't transfer property inter vivos to your kids while they're alive. Don't do that. Okay? But through a deed. You do it through a trust agreement with a competent estate planning attorney, because I can avoid that mess. I can make that happen, avoid the mess, avoid the tax to the extent that you can. All right? I got a little quote for you. Does anybody remember Leona Helmsley back in the 80s? Leona Helmsley, it's a big deal. Her housekeeper testified against her in tax court because she was being convicted or being charged for tax evasion, and her housekeeper said, yeah, she used to brag all the time, we don't pay taxes, only the little people pay taxes. Well, that ended up getting her about 18 years in jail, that comment. So we're not here today to avoid taxes. We're here to be smart about the tax planning that can take place so that you can save your tax money and use the laws that our legislator and our congresspeople have given us, okay? What happens without an estate plan? You leave your surviving spouse and children vulnerable and with less assets, just like my mother. Mother was vulnerable. She needed things. We were just minors. We weren't able to help her, and she had to do what she had to do, and it's kind of sad. And you don't want to work your whole life and have the IRS or a creditor or someone take your stuff. You want to plan. I'll give you another example. I represent a little old lady in St. George. She's 82 years old. She was referred to me by somebody that said, we've got a big, huge problem. Grandma just hit a guy on a bicycle. He's an Ironman athlete. She wasn't supposed to be driving. She snuck out of the house, wanted to go down to Walmart, wanted to be independent. She got behind the car. She's driving down the road. She doesn't see this guy, and she just runs up right on him. He's also an ER medical doctor, so his lost wages were through the roof. He's a world-class athlete. His claim is worth well over $1 million. Well, she only has $100,000 in coverage from her automobile insurance, which is actually quite a bit. Most people only have 25 or 50. She had 100. Well, $100,000 isn't going to be enough to cover this claim. So we had to we had to be very creative and smart about what we did with her estate in order to protect her estate. You know, she's worth a couple $1 million. If she had done her planning before that event happened, she would be just fine. Even now, she'll be okay with some of the work that we've done, but not nearly as well off as if she'd done the planning before. So if you have parents, if you have loved ones with significant estates that haven't done their estate planning, you need to go work with them or their guardians. Make sure you get this done, okay? Estate planning tools. This is simple. You've heard of wills. Wills are simple. Give all my stuff to these people. They're not flexible. They're not pliable. They're durable. They last a long time, and if you do them right, they're actually effective. I don't think that I've ever done a will, just done a will for somebody. I don't think there's any reason to do that. There's no reason to just do a will. Now, you can have a will in combination with a living trust, and that makes a lot of sense. So living trust, wills, durable power of attorney, DPOA, that's pretty simple. It says, Sonny, if I'm from this point moving forward, I'm appointing my wife, Bandy, to be my attorney in fact, and she can make all these financial decisions for me. I also have one called a general power of attorney for health care. And it says, if I'm incapacitated, Bandy, you can make any decisions that need to be done for me. Those are tools. Prenuptial agreements, living wills. A living will is one of your most important documents, in my opinion. That's called an advance directive or living will. It says, you know, if I'm a vegetable and 2 or more doctors say that I'm going to die, then and I can't make my own health care decisions, here are the list of directions for my agent that I want to be done and executed. One of those is maybe a do not resuscitate. Don't resuscitate me. Don't let me be a vegetable. Give me pain medication. Make me comfortable until I die. Now, don't use CPR. Do use CPR. Don't give me stem cell treatment. Do give me stem cell treatment. A lot of decisions need to be made when somebody gets Alzheimer's and they don't know who they are anymore. And so who's going to make those decisions? If you have a good advance directive or living will in place, your mother or father or you or your wife will have already made those decisions, and then it's just up to somebody executing them. Saves a lot of family fights. Remember the Terry Schiavo case. Terry Schiavo was, I think she was involved in a catastrophic car crash, and for 20-something years, she could move her head and she could bring a spoon up to her mouth, and she looked like she was there. There was some cognitive thinking there. Turns out she was absolutely brain dead. Husband wanted to move on after 20 years. He said, look, she's not going to ever come out of this. I want to move on. Mom and Dad stepped in and said, do not pull the plug. She's our daughter. You move on, go do what you want to do. And he's saying, I can't move on. I know she wanted to die, and I'm not going to let you keep her alive. Millions and millions of dollars, huge TV coverage all over that case. I think it was back in 2002 or 2003. And that could have been avoided if she had simply done her advance directive or living will. You don't even need to pay somebody to do it. Go out on the state bar's website. They have a form. But do your advance directive, do your will, or do your living will. Does anybody in here have a business that they own or a part of or a member of? Business succession planning is the very first thing that you need to be thinking about when you leave here today. You may already have that in place. If you have it in place, have it reviewed, okay? You need something called it's called a buy-sell agreement. It's an agreement between you and your partners. This is how I'm going to exit the business if I want to. Here's what's going to happen if you want to exit if you want to. Okay? Does that make sense? You need a buy-sell agreement. You need some kind of business succession planning, and then you need something in your estate planning that says, husband, wife, how are you going to take care of wife's interest in the company? And where's the buy-sell agreement? What does it look like? Okay? And gifting. I love gifting. Gifting is an interesting concept, and you can gift your estate down so that when you die, you don't have estate taxes. Now, I'm going to pretend today like the estate tax threshold is $1 million. I'm not even going to tell you what it is right now because it'll take me 20 minutes to explain it. It's complicated. But in 2013, me and the vast majority of planners, we believe that it will be $1 million. The estate tax threshold will be $1 million. So let me give you a theoretical. I have $1 million estate. My wife has $1 million estate. We each own 50% of a $2 million estate. I die. By operation of law, my planning, my 50% goes to her, and she now has a $2 million estate. No taxable event there. You can pass everything on to your surviving spouse with no taxable event. But now my wife has a problem. She has a $2 million estate. What if she died the next day? Or what if we died simultaneously? Well, then you've got a $2 million estate. You can exempt $1 million, and somebody somewhere says, the IRS says, hey, you have $1 million in excess of the exemption. Write us a big check. 42, 44% of that will go to the IRS as an estate tax. Okay? On that hypothetical. So that's 420, 440 grand goes to the IRS that your kids are paying that tax. So it's easy to use the plans and the rules that we have in place to do that. Well, that's a summary on why you need an estate plan, when you need to do it, what are some of the estate planning tools, and what are some of the things that you can do to avoid the inevitable problems of not doing your planning.
Well, thank you, Sonny, for coming down today and talking to us about the importance of estate planning. And thank you all for joining us today. And thank you, Channel 17.